you guys, welcome back to my channel.
The day KJ and TATI Westbrook have been waiting for has finally arrived. Finally, the judge has given her ruling on the issue of jurisdiction, and we're gonna read the paperwork and talk about it, because KJ has won this round.
But before we start, do not forget to go down below and subscribe to the channel and ring the bell button so you can get notified every time I post.
Also, as a quick disclaimer, I just want to remind you guys that everything we discuss here in the channel is my opinion, and my opinion only, not to be taken as a fact. Always do additional research from the information that you get here in the channel. Do not send any hate to the people that I'm going to be talking about in this video.
Am I right, fellow adult?
However, I do encourage all of you to go in the comment section and let me know what you think about the situation.
Let's go ahead and read the order granting defendant's motion to dismiss for lack of personal jurisdiction and denying defendant's motion for sanctions. It should be pretty quick because it's just 13 pages. This ruling is basically in favor of KJ, giving her the motion to dismiss because of the lack of personal jurisdiction. However, the judge is denying the sanctions filed by Brown. This matter comes before the court on a motion to dismiss filed by defendants and on a motion for sanctions also filed by the defendants. The motion to dismiss sets forth multiple grounds for dismissal, including lack of personal jurisdiction, lack of diversity jurisdiction, failure to join necessary parties, and failure to state a claim on which relief can be granted. If this is your first time hearing about this, or if this is not your first time and you need a refresher, I have a playlist and various videos about it. I'm going to leave the playlist down below in the description box. Go ahead after this video and catch up, or stop now, go catch up and come back to this video. And just a quick reminder, YouTube keeps on subscribing you guys from my channel. So if you are a subscriber, just take a quick second and check if you are still subscribed. And if you are not a subscriber yet, don't wait any longer and go ahead and press that subscribe button now. The motion for sanctions seeks an award of sanctions against plaintiff's counsel, Michael Saltz, for alleged conduct related to the declaration of Lori Barnhart. Plaintiffs opposed both motions. Having reviewed the parties' beliefs in support of and in opposition to the motions, the relevant exhibits and case law, and the remainder of the record, the court grants defendant's motion to dismiss for lack of personal jurisdiction and denies defendant's motion for sanctions. The court's reasoning follows. Clearly, KJ has won this part of the fight, but let's keep reading it and see the reasoning behind it, and hopefully we'll see some twists. I'm really hoping for some twists. I have not watched Emily D. Baker and see what her take was on it, and I literally have not written the paper until right now while filming this. Tatiana Westbrook is a self-described internet personality, celebrity, and influencer who critiques beauty products and posts those critiques on social media platforms, including YouTube. She claims to have over 9 million followers on YouTube alone. Plaintiff Halo Beauty Partners, Halo, a Nevada limited liability company, is a nutraceuticals company that produces products formulated to support hair, skin, and nail health. Mrs. Westbrook founded and owned Halo with her husband, plaintiff James Westbrook. For purposes of this motion, the court takes as true the Westbrooks' claim that they are and were at all relevant times domiciled in King County, Washington. We have a footnote that says both sides devoted substantial effort to arguing whether the Westbrooks were at all relevant times domiciled in Washington. Even plaintiffs deny. However, the plaintiff's domicile is relevant to the inquiry of whether personal jurisdiction exists over defendants. And furthermore, the court, as it must for purpose of this motion, takes plaintiff's allegation concerning their domicile as true. Clearly, the domicile issue that they discussed on their motion to dismiss has been addressed in this part of the ruling. Defendant Katie Joy Polson is a resident of Minnesota. Her company, Defendant Without a Crystal Ball, is a Minnesota limited liability company. Polson is an internet, quote-unquote, blogger and vlogger who makes, produces, and uploads drama and/or tea videos and internet postings on various internet-based platforms, including but not limited to YouTube and Twitter. Defendants have an estimated 135,000 YouTube followers. According to the complaint, starting in May 2019, defendants have uploaded to YouTube and Twitter dozens of videos targeting the Westbrooks and Halo, designed to quote-unquote ruin Miss Westbrook's good name and reputation. These videos are presented as exposés covering a range of subjects, including 1. A public dispute between Miss Westbrook and a rival/fellow quote-unquote beauty celebrity James Charles. 2. The safety and efficiency of Halo vitamin products which Poulsen has referred to as snake oil. 3. The personal and business history of the Westbrooks, including alleged legal disputes and business failures. And 4. A lawsuit filed in October 2020 in Los Angeles Superior Court by plaintiff's business partner Clark Swanson against Halo Beauty Incorporated and company affiliated with plaintiffs. Plaintiffs claim that in these videos, defendants have intentionally harassed and maligned plaintiffs and/or otherwise maliciously portrayed them in a false light and sought to financially harm them. Defendants' video have been published to and/or are accessible by the general public and have been viewed hundreds of thousands, if not millions, of times. Plaintiffs have sued defendants for defamation, intentional infliction of emotional distress, and violation of the Washington Consumer Protection Act, among other causes of action, and seek $5 million in damages. Defendants move to dismiss plaintiffs' claims under the listed law for lack of personal jurisdiction. Because the court grants defendants' motion to dismiss on these grounds, it does not reach defendants' remaining challenges to the complaint. As per my understanding in this part, Barb's is saying that even though she's dismissing for jurisdiction, it does not mean that KJ has won the case and she should or could still respond to the defamation if Tati decides to refile it in Minnesota, which I believe and hope she will. General principles on a motion to dismiss for lack of personal jurisdiction. When a defendant moves to dismiss for lack of personal jurisdiction, the plaintiff bears the burden of demonstrating that jurisdiction is appropriate. Barb lists a case that was Schwarzenegger versus Fred Martin Motor. If I'm not mistaken, Saltz was involved in this case, so I find it pretty interesting. Was that Judge Sass? Maybe? All of a plaintiff's uncontroverted allegations are taken as true, and factual disputes are to be resolved in plaintiff's favor. My understanding here is that when Tati filed her complaint, everything was taken as face value, as fact, as true. Once KJ filed her motion to dismiss, Tati's law team had to bear the burden to prove that the jurisdiction made sense and the whole entire case should be heard in Washington. In the absence of applicable federal law, jurisdiction is governed by the long-arm statute of the state in which the court sits. And then she gave another example of another case. Washington's long-arm state extends personal jurisdiction to the broadest reach of federal due process. Because this is a case over the internet and there's difficulty finding out where are the lines here for the jurisdiction, they have to follow the regular laws that already exist. Even though they are not very appropriate for this generation of internet and cyberspace, unfortunately, there's no way to deviate and they have to follow what is already established. To comply with the requirements of due process, a plaintiff must demonstrate 1. That the non-resident defendant has established minimum contact with the forum state, 2. That the exercise of personal jurisdiction comports with the traditional notions of fair play and substantial justice. Courts apply a 3-part test to determine whether the non-resident defendant has the requisite quantum of minimum contacts with the forum state for the exercise of specific jurisdiction to be appropriate. 1. The defendant has to purposely directed his activities towards the forum. 2. The plaintiff's claims arise out of those forum-related activities. And 3. The exercise of jurisdiction is reasonable. This page also has a footnote that says personal jurisdiction may be general or specific. General jurisdiction requires that the defendant's contacts in the forum state are continuous and systematic. Because plaintiffs here do not claim that defendants are subject to this court's general jurisdiction, the court consider only the question of specific jurisdiction. Defendants challenge the first prong of the minimum contacts test and deny that they purposefully directed their activities towards Washington, whether defendants' actions were purposefully directed at Washington state. The Ninth Circuit has recently acknowledged the difficulty of analyzing personal jurisdiction in the context of internet-based claims, when an individual in one state can cause serious harm anywhere in the world without leaving the comfort of their home. Courts have sought to strike a fair balance between the interests of defendants who may have no international connection with the forum and plaintiffs who may have nevertheless experienced expressed harm, all while maintaining a principled approach to the concept of jurisdiction rooted in due process. Even in this context of constantly and rapidly evolving technology, whether a defendant accused of an international tort such as defamation has purposefully directed its activities towards a forum sufficient to establish personal jurisdiction is still governed by the effects test outlined nearly 40 years ago by the Supreme Court. Under this test, courts are to determine whether the defendant 1. Committed an international act. 2. Expressively aimed at the forum state. 3. Causing harm that the defendant knows is likely to be suffered in the forum state. Apparently, considering prongs 1 and 3, defendants claim that plaintiffs have failed to establish the second element of the Calder's effects test. The defendant's conduct was expressively aimed at Washington. This page also has a footnote that it says it is not clear from the case law what distinction, if any, is intended between the phrases purposely directed and expressively aimed. But for purposes of this case, because defendants have not challenged the first and third prongs, the effects test effectively collapses into the first prong of the minimum context test. We already knew that the entire thing with the internet and social media was going to be a challenge, but to realize that this is based on a 40-year-old test is kind of annoying to me. And I'm not saying that this test as is bad, but there should be some sort of change to accommodate our present needs. The judge moves on to explain how this test came to be. A California television and movie actress brought a libel suit in California state court against a reporter and editor based on an article published by the National Enquirer, headquartered in Florida. In concluding that defendants had expressively aimed their conduct at California, the court noted the following factors were significant. The defendants had reached out directly by telephone to sources in California that the article, quote-unquote, concerned the California activities of a California resident and contained various facts that gave the article a California focus. The National Enquirer sold 600,000 copies of the article in California out of a total nationwide circulation of approximately 5 million, almost twice as many as the next highest state, and that the contents in the article were alleged to have caused an injury to the plaintiff's reputation in the estimation of the California public, and specifically impugned the professionalism of an entertainer whose television career was centered in California. Since Calder, courts have weighed similar factors connecting a defendant with a forum tempered by a recent admonition in Valder versus Fiore. In that case, an anonymous Supreme Court expressively rejected the view that Calder's effects test is satisfied merely by the defendant's commission of an international tort that is aimed at a person known to be a resident of a forum state. Mere injury to a forum resident is not sufficient connection to the forum. The Walder Court noted that the proper question is not whether the plaintiff experienced a particular injury or effect, but whether the defendant's conduct connects him to the forum in a meaningful way. Clearly, she's saying that it doesn't really matter if Tati lives in Washington. What matters is what conduct from Katie connects her to Washington in a way where she actually has to be held accountable for her actions in Washington. As noted above, in the context of internet-based conduct in particular, courts have struggled with the question whether tortious conduct on a nationally accessible website is expressively aimed at any or all of the forum in which the website can be viewed, and have required something more than maintenance of a passive website available anywhere with an internet connection. The Ninth Circuit has found jurisdiction where the defendant continuously and deliberately exploited the forum state market for its website, and a substantial number of hits to defendant's website came from the forum. It has declined to exercise jurisdiction, however, even where almost 20% of the defendant's total circulation was located in the forum, where plaintiffs did not establish that defendant expressively aimed at the forum or tailored the website to attack forum-specific traffic. Whether defendant's suit-related conduct was expressively aimed at Washington, the cases demonstrate that the ultimate question of when defendants defendants expressively aim their suit-related conduct at the forum states is intensively fact-specific. One clear import of the Ninth Circuit's case law regarding express aiming is that the district court's inquiry on this score must be grounded squarely in the facts of the particular case. After examining defendants' connections to the state of Washington, the court concludes that the defendants' contacts in this case are the kind of random, fortuitous, or attenuated contacts with the forum state that Walden cautioned courts against relying on. This does not sit well with me, because what I understand from this is basically the judge is saying if KJ did not do enough towards the state of Washington, they washed their hands from protecting their resident, TATI Westbrook. That kind of like, I don't know, I don't like it. Now we move on to the alleged connections KJ had with the state. Sources for the content. Plaintiff alleges that defendants searched through and relied upon Washington sources for their information. The evidence demonstrates, however, that conducted several different searches using general internet search engines, looking all over the place, everywhere, and then she lists one of the videos. AJ did a regular, very basic background check and also noted you can actually go state to state and try to pull up some stuff as well. Plaintiffs argue that KJ must have used Washington-specific websites for her research, a reasonable inference from the content of her videos. However, it is also clear she likely used state-specific websites from multiple other states as well. Citing June 2nd, 2019 video, The Past James and Tati Westbrook Don't Want You to Know. The past video. KJ stating, in Georgia, all of this is public record. Unlike the Calder, there is no allegation that defendants reached out directly or indirectly to any resident of Washington for information for the videos. Plaintiffs claim that defendants relying on Washington sources is significantly overstated. Focus on plaintiffs' activities in the forum. Also, unlike the article in Calder, which was focused on Jones's activities in the forum, defendant's video does not refer in any substantive way to activities conducted in Washington. Plaintiffs' preferred examples of defendants' references to Washington are brief, isolated, and incidental. Tati grew up in Washington and her mother actually was her talent agent. Tati and her family moved around a lot. Other than a brief reference KJ makes to Tati's small tax warrant in 2003 in Washington, lasting mere seconds of the hours and hours of videos at issue, the court was unable to identify any explicit reference to Washington that might arguably impugn the Westbrook's reputation. Critically, almost none of the few Washington references in the defendant's video are connected to the underlying defamation claims in this case. Instead, the majority of defendants' alleged offending content concerns events and subjects such as Tati's feud with James Charles and the Los Angeles lawsuit Clark Swanson filed against Halo that took place in California or virtually online. Defendants' discussion of plaintiff's vitamin products is directed at plaintiff Halo, a Nevada company, and none of Tati's YouTube videos, the frequent topic of defendants' videos, was apparently filmed in Washington or even concerns activities that took place in Washington. This is in contrast to the situation in Calder, where the court reviewed the various facts that gave the article a California focus and concluded California is the focal point of the story. So far, I'm really disappointed, and I see why she's doing what she's doing, and I understand why she's ruling the jurisdiction based on this 40-year-old law, and she needs to follow that because she's a judge. However, it does make me feel like now, in this day and age, we can just defame someone on the internet and we're probably gonna get away with it, because no judge is going to take jurisdiction because it's over the internet. This is just beyond insane. Activities directed at large number of citizens of the forum. Calder and its more recent progeny also indicate that a plaintiff must demonstrate that the offending content both reached a large number of forum state residents and was intentionally targeted at the forum. In Calder, the reputation-based effects would not have occurred but for the fact that the defendant wrote an article for publication in California that was read by a large number of California citizens, finding specific jurisdiction appropriate in state where substantial number of copies, 10,000 to 15,000 per month, are regularly sold and distributed. I don't know if Barbs understand the fact that these videos may stay online for many years, so there's a potential of much more than 10 to 15,000 people seeing them in Washington. I don't know if she gets it. As more recent cases dealing with internet-based injury establish, it is not enough that a defendant's content is merely accessible to residents of a forum. Not all material placed on the internet is solely by virtue of its universal accessibility, expressly aimed at every state in which it is accessed. Where the plaintiffs does not identify any evidence that defendants specifically targeted or solicits forum state viewers, the forum state residents' ability to view defendants' online content alone is not enough to demonstrate express aiming. She does a couple of other case citations, and then it says plaintiffs does not present any evidence to show defendant's website has a specific focus on California or has a substantial California user base. Plaintiffs profess no evidence to show defendant posts and profits from California specific advertisement on its site. Furthermore, the online stock and commodities trading market cannot reasonably be considered a California-centered industry, unlike the celebrity gossip industry described by Marvix Photo Inc., which arguably revolves around Hollywood, California. An industry to which defendants belong is not specific to one geographic area. So am I to assume that every court's just gonna say fuck it, I don't care, and everyone can just defame everybody in the internet? It sounds so wrong. The court takes as true plaintiff's bare-bone claim that defendants' viewership includes residents of Washington, but the factor alone is not sufficient to support their bid for jurisdiction. In support of their claim that jurisdiction lies in Washington, plaintiffs have submitted 1. Declarations of 2 Washington residents who viewed defendants' videos and based thereon decided not to buy plaintiffs' products, and 2. The declaration of one of defendants' fierce and loyalist fans, a Washington resident who subscribed to defendants' YouTube channel during the time period that AJ published numerous videos and other content maligning plaintiffs in this case. Even crediting the testimony of the 3 witnesses, the declarations of 3 viewers in Washington. Out of the alleged hundreds of thousands, if not millions of times, the defendant's videos have been viewed, only highlight the vast discrepancy between this case and the 600,000 California readers in Calder. She cites another case, which is one of the many cases that she's been citing, and it says jurisdiction existed because substantial number of hits to defendant's website came from California residents. Emphasis added. Court lacked jurisdiction even though 20% of defendant's audience lived in the forum. Significantly, plaintiffs have referred no allegations of, for example, Washington-specific marketing or advertising from which one could conclude the defendants targeted Washington as opposed to a wider audience generally. The court finds that plaintiffs have failed to demonstrate the defendants expressly aimed their video content at Washington and thus have not shown the defendants purposefully directed their actions towards the state of Washington. Therefore, the court concludes that Washington is an improper forum and this court lacks personal jurisdiction over defendants. I know I said this before and I'll say it again. I see what she's trying to do with her decision. However, it shows that she has very little to no understanding how YouTube and social media actually work. Defendants' motion for sanctions. Defendants have filed a motion seeking sanctions against plaintiff's counsel Michael Saltz, essentially accusing him of harassing and intimidating third-party witness Lori Barnhart and of both suborning and committing perjury, which provides that the court may order any attorney or other person admitted to conduct cases who so multiplies the proceedings in any case unreasonably and vexatiously to satisfy personally the excess costs, expenses, and attorney's fees reasonably reasonably incurred because of such conduct, where ordered, these sanctions must be accompanied by a finding that the sanctioned attorney acted recklessly or in bad faith, or committed intentional misconduct. Bad faith is presented when an attorney knowingly or recklessly raises a frivolous argument or argues a meritorious claim for the purpose of harassing opponent. The court declines the rule on defendant's motion for sanctions for several reasons. First, the misconduct alleged is serious, and if proven, could expose SALT to sanctions up to and including disbarment. Given the gravity of the potential consequences, and because defendant's allegations are both convoluted and heavily disputed by Brown himself on his own motions, the court could not rule on the motion without an extensive evidentiary hearing. Furthermore, because the Barnhart Declaration is not material to the court's ruling on jurisdiction, the integrity of these proceedings is not implicated to the extent that defendant's content. And while the court acknowledges it has the discretion to rule on the motion, the fact that this case is being dismissed means the court's supervision on these proceedings is no longer required. In sum, the court declines to devote its resources to investigating the activities of a California attorney not licensed in Washington in a case that's being dismissed. The motion for sanctions is therefore denied without prejudice. In conclusion, for the foregoing reasons, the court grants defendant's motion to dismiss. Defendant's motion for sanctions is denied without prejudice. This case is dismissed without prejudice. I have so many opinions about this, it's not even funny. Although it was expected, we kind of knew that this was going to get dismissed. Well, we knew that there was a high chance that this case was going to be dismissed in the state of Washington, and probably it was going to have to go to Minnesota. The reasoning she gave for this dismissal was really disappointing to me overall. It just highlights the fact that we do need a reform, because nowadays everything is online, and trying to do things the way that she explained they're done, it's just not good enough. Another thing that I noticed, that when we got to the sanctions part, I appreciate that she took the time to evaluate Brown's contradictions on his paperwork, but I also got the vibe that she was just like, you know what, I'm tired of all of this. I don't want to deal with these people. Let me just dismiss this and let another judge deal with the circus. She denied the sanctions without prejudice, which means Brown can again file another one in the next jurisdiction, because she also dismissed the case without prejudice, which means that Tati can go ahead and file the case again in KJ's state. I do love the fact that she completely ignored the motion to qualify that Brown has filed, but I do have a very strong vibe that she just does not care about this and she just wants to get rid of it and move on. Now that I gave you guys my opinion, I want to know yours. Go down in the comments and let me know, what do you think about this dismissal? Do you think that Tati is going to refile this in Minnesota? Do you think that these lawyers are going to drive this new judge crazy as well? Let me know down in the comments. I'm super curious to know what's your opinion. Also, we have discussed on Twitter that we might do a live about the situation. I want to know how many of you want a live. So go ahead and press the like button so I can have a better idea of how many of you who are watching this video will come over to the live and have some fun and discuss the situation. This is it for me, you guys. Thank you so much for watching. Don't forget to subscribe to the channel before you go, and I will see you guys in the next upload.